And this matter comes before the court today on defendant slash intervener Kathy Juarez emergency motion for temporary restraining order and preliminary injunction. I would invite counsel to place your appearances on the record.
Stephen Grimm and Ben Grover for Juarez.
Thank you.
Good morning, Your Honor. Austin Bodette for the plaintiff, John Tetzlaff.
Very good. Thank you, Mr. Bodette. Mr. Grimm, this is your order, and I understand portions of it that intervention was allowed in this case, and we don't need to then take that up. The only remaining issue, it looks to me like, is the question of a restraining order or a preliminary injunction.
I believe that's correct. I don't believe that. That is correct.
All right. Well, then I guess my, question goes to you is, it looks to me like, well, there's a sale pending on this house. We don't know, of course, what the proceeds, if any, of the sale are going to be, because, of course, they're in houses and things like that. There can be a bank out there, with their hand legitimately first in line for any money from that. But, Judge, if there is any money, we'd like it placed in a restricted account. I don't think I can put it in a court account unless it's an interpleader. However, you're looking to escrow the money perhaps at the title company or
Well,
different. What are you looking for?
Well, I think one option, Your Honor, would be either keep it with Mr. Grover knows way more about this stuff than I do, but I think one of the options would be, and I would be fine with this, whatever's easiest, but I would be fine, I think, if we put it in the Willis Law Trust account. That might be the easiest thing with an instruction or an order from you that it does not leave, not a penny leaves that account until you order it.
Okay, all right. Well, let me hear what Mr. Bodet's argument with that regard is going to be.
Thank you, Judge. I believe that Ms. Juarez's request for a TRO fails here for two reasons. First, she's unlikely to prevail on the merits, and second, there's no irreparable harm. As to the merits here, there's no underlying claim that she's even filed to even prevail on in this. Court of Appeals in Redmond held that an injunction is a remedy, not an independent cause of action. And because the remedy must be supported by an underlying cause of action, the trial court couldn't enter an injunction in that case. Even
Well,
if
I
we put
suppose
that,
she's going to say, not to get put words in Mr. Grover and Mr. Grimm's mouth, that, well, I am intervening here, and, well, the very least I'm going to get out of this is, the payment for Mr. Tetzlaff of half the fees for the arbitration proceeding that I think I dismissed the substantive cause of action before to order this thing into arbitration. So, I suppose she's going to say, well, whatever happens there, I'm going to get at least that portion of the money, which is some 60 grand. Um, I get your thing. You're saying, well, you're very much putting the cart before the horse, which normally in a circumstance like this, I'd agree with. But it seems like she's fairly likely to at least recover that 60 grand. If that's the case, giving her some likelihood of prevailing on the merits, and she's now intervened in the case, so she's actually a party. Um, what would prevent me, or why shouldn't I grant the restriction of these funds?
well, Judge, I think I see the point there on the underlying arbitration proceedings, but to my point, I would say that the arbitration proceedings at this point, it's a confirmation and a potential vacation of the award. It's not an underlying claim per se. But even if we put that procedural issue to the side here, Ms. Juarez's position is that the sale of plaintiff's house constitutes as a voidable transaction under Section 34 of the Voidable Transactions Act. And if we look at Section 34 there first has to be a voidable transaction. And as relevant here, Ms. Juarez would have to show that either plaintiff made a transfer with the actual intent to hinder, delay, or defraud a creditor, or that he transferred the property without receiving reasonable equivalent value under the circumstances identified in the statute. And there's no evidence of either here. There's no allegation that this is anything other than an ordinary sale of plaintiff's residence for fair value. And there's no evidence that plaintiff listed or sold his house with the intent to hinder, delay, or defraud anybody. Instead, Ms. Juarez's argument is based on speculation on what plaintiff might do with the money after the closing. Her brief says that the proceeds will be commingled, moved, spent, and transferred within days, but there's no evidence to support that assertion. And I would say, Your Honor, even if plaintiff later transfer those proceeds, puts it in a different account, the mere transfer or expenditure of money itself is not unlawful under the statute. The issue under Section 34 would be whether a particular transfer was made with the intent, actual intent, to hinder, delay, or defraud a creditor. And so what Ms. Juarez is really asking this court to do is assume that plaintiff will engage in a future wrongful transaction and freeze his assets today based on that assumption, which turns the statute backwards in itself.
Okay. All right. Well, no, I think I understand that argument. Let me bounce back to Mr. Grimm or Mr. Grover. Only one of you gets a bite at the particular apple, though, so you're going to have to figure out who it is. I recall from, 1,000 years ago of asking for and arguing TROs that one of the other factors that I evaluate along with success on the merits is there another less drastic or extraordinary remedy that would solve this problem? And it sort of seems to me, well, at the end of the day, if there is a fraudulent transfer of those funds and that results in no money being available to pay, a judgment that I might presumably enter in the future in favor of Ms. Juarez, why don't you just then pursue the fraudulent transfer action? And, in other words, there's a financial judgment enforcement remedy that could be followed here, granted much more painful and slow for Ms. Juarez, but as you know, us judges in the law are rarely concerned with such matters of time value of money, given our glacial pace here at the court. So how do I get past that idea that, there's a pretty clear financial remedy here that could be awarded via money judgment, or, ultimately, there's another way to enforce this thing rather than locking up assets in an extraordinary way?
Oh, that's easy because there's not. It's pretty simple. The voidable transfer is not the sale of the house. The voidable transfer is him taking the money and paying himself. We know, for example, that in the filings that they have, that Dawn Tetzlaff does not have an interest in the property. If you look at their filing, the divorce decree says that the judgment of divorce says that he had to pay her $87,000 before the entry of judgment. And we know Judge Alspaugh, who knows what she's doing, she did enter the judgment of divorce. So this idea that, that she has half of the value of the house, that's just not true at all. Because at worst for them is the fact that if the only thing he had to pay on that judgment under the mediation agreement would have been $87,000 left, because the document itself says that he satisfied the other $113,000. So there was only 87. So there's that. And then the other thing is that
well, let me just pause you. Doesn't that say, and I by necessity have become a somewhat proficient at reading between the lines, maybe Mr. Tetzlaff has resources beyond the equity that he has in his house, and that, again, if you obtain a judgment against him, which is obviously your goal in the matter, that, you'll have some assets to enforce against.
No, that's not true, because we know from this case that he can't even do a capital call in the amount of $25,000. He has stolen so much from this company. We have an award. We did, Judge, exactly what you told us to do. We followed your order to the letter. We did under the operating agreement. It was paragraph 12.1. And that paragraph said that's what you relied on to order this arbitration, such as it was. I don't still agree that it was an arbitration, but call it what you want. We did what you said. And so the panel, under that provision, the panel awarded $655,000 to the legacies. Now, the legacies isn't a party yet. Well, they are now in this case right now. but that award has to go to the legacies. And the problem is that like I said, Tetzlaff can't even do a capital call. He stole $655,000. So all of that money, I don't know where it went, but it's clearly gone. Because what we have now is this award of the panel of 655,000 to the legacies, which you're going to decide. And what do they say? They say, well, it's only half of that because they were distributions. You're going to find out they were not distributions. He stole the money, and that's clear. And we'll brief that when the time comes in this case. But there are no assets there. And another thing we found out, Judge, in this thing is that back in June of 2025, let me back up, May of 25, Mr. Grover wrote Mr. Tetzlaff offering him a walkaway because we had an idea of how much he stole. He didn't take that deal. And so on June 6, 2025, we filed our complaint. That was 7 days after we gave him the notice, and we said, if we don't hear from you in 7 days, we're going to file suit. That same day, he listed the Eaton Rapids house, which was the other property subject to that divorce. And again, that was 1 week after we said that we were going to sue him. So this is what this guy does. Then on July 9, the Eaton Rapids house sold. And then after that, he bought his daughter, Liberty Tetzlaff, a house in Florida, which he uses. And this is all to avoid creditors. It's all to commit a fraud on the court. And the court may remember that we had alleged that Liberty Tetzlaff was participating in his fraud scheme, and that they vehemently denied that, and they were offended by it. Well, during this arbitration proceeding, which you're going to find out, that they admitted that she did participate in this fraud scheme to the tune of about $100,000. Okay, so this is what this guy does. Now, there is no remedy at law because he doesn't have the money, like I said, to even pay half of a capital call. He doesn't have the money. He wants to take out another loan. This company is put in this position that there is no remedy because they are very likely not going to, if he doesn't meet the capital call, they will likely not meet payroll. They have a large tax bill coming. If they don't meet that, they'll lose their lease. Credit cards have been declined to buy groceries. Katie Juarez had to sign a personal guarantee on a note just to get a refrigerator. So while she's trying to run this company for these poor elderly people that need this facility, he's running it into the ground. And so to allow him to skate on this fraud, which is another fraud on the court, because what we got is a 655 award. It's not a judgment until you say it is, but that is an award from the panel that you said we had to do, and it's binding under the paragraph 12.1 on the parties. And so what we're saying is if you allow him to skate on this when there is absolutely no indication that his wife has any interest in that house, that would totally, we would never be able to get it. There is no other remedy. Now, here's the thing. If we do this sort of in the form of, and I will also say that under the Voidable Transfer Act, if you look at 566.371C1, that provides for just this very type of injunction. And if you wanted to do it this way, we could have make it in the form of a TRO, and we can develop this over the next couple of weeks, and we can have a hearing on a more formal injunction. But we've got to preserve those assets for the legacies.
What about, another alternative that came to me, in doing this was asking the Mr. Tetzlaff to post a bond. Why, if you think you're going to prevail on the arbitration award, my recollection of the Michigan court rules is they do have a provision in there where the court can order posting a bond, and that way, I kind of keep his financial options open, but I say, you know what, you better give some assurances that if this goes against you, you're going to have some money to pay. Is that an option here?
Well, Mr. Grover knows more about that than I do. If he posted a bond in the amount of $655,000, I know we're not supposed to both talk, but can I just see if Grover's okay with that?
Yeah, I think we can allow Mr. Grover a moment on that.
That sounds fine.
All right, well, let me bounce back to Mr. Bodek. You know, as I view it, you know, if I order a performance bond or defendant to post a bond in the matter, you know, it gives him some financial flexibility because I'm not tying up a specific pot of money. Rather, I'm just saying, hey, I want some assurances that that money is not going to disappear during the pendency of the action. Is that a reasonable remedy?
Judge, I would say it's not. And the reason I would say it's not is because, again, I think that there is a remedy here at law for Ms. Juarez. If there is a voidable transaction in this case, if Mr. Tetzlaff does something with this money, they have a remedy by statute. That's Section 37. That's what they're arguing here. They're just putting things before the matter is right in this instance here. Again, if he let's say Mr. Tetzlaff goes and buys a property down in Florida with the funds currently, once the sale of the house goes through, that would be a voidable transaction, arguably, under the statute, and they would have a remedy for that. They could bring a claim for that and seek to avoid that or levy an attachment on that house under the statute.
Suppose they could slap a lien on that house down in Florida, you know, once they
Florida
have
is such a
judgment up
debtor's-
here and enforce
Florida
it.
is such a debtor state that would never work. And that's not a realistic thing. That's just absolutely unrealistic. And this guy's got a history. So the bond thing is perfect, honestly.
It's certainly a long ways from putting any money into the legacies or you know any potential judgment out to Miss Juarez if you got a lien on a house. The lien on the house in Florida doesn't buy a whole lot of supplies.
Groceries.
Well, and Judge, the statute says they can void the transaction altogether. And so that's the remedy here that they have. They have that option. If
Sure.
something were to go awry with those funds, there are options for them here. Again,
Well-
there is an avoidable transaction that has occurred yet that would authorize this type of relief.
Yeah, I would agree on the idea that you know, freezing a particular pot of money here it would be an extraordinary remedy, and I mean further, you know, just from a practical sense, I view it as you know that the concern there would be right. Obviously, money is fungible, but then again, capitalist country. That's how we. It turns out that's how we both speak in the terms of free speech, and it's also, of course, how we do all our commercial transactions. Is they're denominated in money. I think that is too extreme a remedy. However, I do believe that an appropriate remedy here would be the posting of a bond, performance bond by the defendant, Mr. Tetzlaff. And the reason I think that's warranted here is, you know, it's very clear. I have had presided over this case for a while. Mr. Tetzlaff has financial interests in obviously the legacies here. He has multiple houses. He's been through a divorce. And he has a daughter who, you know, has well received financial support from him, and you know, also, and I recall at the outset of the case, anyways, I think Mr. Tetzlaff primarily resided in Florida. Now, Mr. Tetzlaff may, in reality, have more than enough money to cover all the obligations. Whatever comes out here, of course, none of that is visible to the court, or probably very much to the parties in the case, or at least the opposing parties in the case right now when it comes to Mr. Tetzlaff. However, the amount of the performance bond is another fair question here. You know, the only certainty I can say is, well, he's probably going to have to pay his portion of the arbitration proceeding in the amount of some $60,000. You know, and I think it's also fair to say that, you know, at least a half of that award, given this is at least my recollection, a 50-50 type LLC with two co-owners would also be. What was the total of the arbitration award, Mr.
It's 55.
55 was the cost of the arbitration. What
No,
was
the award was $655,000.
All right, so I'm going to cut that in half and make it 325 plus 55. 300, Mr. Tetzlaff to post a performance bond with a suitable surety company in the amount of $380,000.
Okay.
But the request for the TRO on the funds and a preliminary injunction is denied.
Would you like us to do the order?
Yes, please.
Thank you, Judge.
Thank y'all.
Thank you, Judge.
And this matter comes before the court today on the defendant's joint motion for a protective order regarding certain discovery that's been requested in this matter. So as an initial matter, I would invite counsel to place your appearances on the record.
Good morning, Your Honor. Patrick Sweeney of Winsluggett on behalf of defendant Grand Rapids Kent County Convention Arena Authority.
Thank you.
Good morning, Your Honor. Sarah Hartman, Deputy City Attorney for the City of Grand Rapids, representing the City of Grand Rapids.
Thank you, Ms. Hartman.
And Ron Vanderveen on behalf of the plaintiffs, Your Honor. And with us here also is Dan Hibma and Hal Fruit, both of them plaintiffs. Mr. Hibma is a plaintiff through owning 3203 PTC LLC.
Very good. And I also recognize Secretary Land here as well.
Oh, and,
So
yep.
very well, we can, with all in attendance, we can proceed at this time. And my understanding, Mr. Vanderveen, is that you have some discovery out there. It was propounded, you know, well, I guess you could probably clarify for this. There's a First Amendment complaint that's already been filed.
That's right. I think it was late April that was filed.
Okay. And we also have a pending motion for summary disposition that I think I'm going to hear next week. Is that all accurate?
That is accurate. Yes.
And is that motion for summary disposition, don't worry here, Mr. Sweeney and Ms. Hartman, I'm going to give you a chance to weigh in on this. It regards the First Amendment complaint or the original complaint?
First amended complaint, I believe.
Okay. All right. So their view is, Judge, you're going to kick this whole case out as premature or not not appropriate for disposition at this time, and thus this whole discovery matter is going to go away. Is there any harm, I guess, Mr. Vanderveen, if I I push the pause button on the discovery and I decide this all in a lump sum next week?
Well, Your Honor, it depends on how you were to decide the case. And I don't mean the yay or nay on the motions, but I mean which arguments you decide it upon. The defendants have argued that the harm from the loud sounds here, the nuisance violations, are hypothetical and speculative. Which
is true until the first concert got played in that amphitheater, I'm sure, and then it became very real, not speculative anymore.
Exactly, and that happened in May, starting in May with the concerts. And one of the things that we've asked for would be records of their recordings, their sound recordings, sound level recordings, to be able to refute that it's not hypothetical and speculative in their motions. Another part is that the city has argued, we're out of this now. We deeded the property over to the Arena Authority. And what we've asked for would be copies of documents, any agreements between the city and the Arena Authority and their communications, to be able to determine, is that really the case? And, once they argue that they've turned things over to the Arena Authority, and they should get summary disposition based on that, that becomes really a C-10 motion, and we're entitled to do a discovery on that. And it would be relevant to that issue to have that information. We've also asked for the city manager's approval of late concerts under section 966 of the ordinance, and what's going on there and the criteria he's adopted there. That's relevant basically to determine whether we have, additional twists to our claim in the complaint. But that's why the first two items especially are why it's important to have this discovery information. in relation to the motions for summary disposition. If the court were to say, we're going to disregard all of the arguments that the defendants raised, except for what are the conditions imposed by the Planning Commission in their minutes, and does the ordinance apply as a matter of law, as not section 9.65, then the discovery is irrelevant. But because they have all these other arguments in their motion, the discovery is relevant. The documents, the records should have been produced early July, in time for us to be able to review them before responding to the motions for summary disposition.
I see. So your argument, I think, is that, right, at least part and parcel of these may be relevant to my decision on the pending motions for summary disposition up next Friday.
Correct.
Okay. All right. Well, let me turn to who wants to speak first? Ms. Hartman, Mr. Sweeney.
I can go first, Your Honor. Just to clarify, this is not a nuisance case. We can go back to look at the Second Amendment amended complaint. The plaintiffs have not brought a
Please
nuisance.
tell me we're not going to do the Second Amendment here. Second
sorry.
Amendment complaint I can deal with, but I didn't see any
the-
Second Amendment
yeah, the
issues.
first- I'm
I've ruled
sorry,
on
Your
those
Honor.
before and been overturned at least once, if I recall, by my colleagues on the Court of Appeals. So I'm going to avoid Second Amendment for today.
No, I appreciate that. The amended complaint is a declaratory judgment complaint. They're asking the court for 3 rulings. They want a ruling interpreting the Grand Rapids noise ordinance, a ruling interpreting the Planning Commission's special use permit for the amphitheater, and then a declaratory judgment ruling making a legal finding as to what could constitute a nuisance per se. That's really the basis for our objection to these discovery requests. As we said in our briefing, we think a lot of these discovery requests would be relevant and appropriate if there was a nuisance claim being advanced here, but there's not. All the court has to do to rule on the claims for relief in this amended complaint is look at the Grand Rapids sound ordinance and look at the Planning Commission approval. So
What's your motion for dismissal based on, Mr. Sweeney? Which court rule?
C8, it's a C8 on the pleadings.
Right, which of course then does permit for them to file an amended, if I'm going to grant the C8 motion, one of the remedies potentially is that they amend their complaint. Let's just make not too far a leap. And is this a situation where they can simply amend to alleged nuisance and we're right back where we are today?
Yeah, I believe that if the court were to grant their motion, were to grant our motion for summary disposition and allow them to amend, then yes, they could bring a nuisance claim.
And then all of a sudden, the stuff that they think that they're entitled to discovery wise, all of a sudden then may become relevant at that point.
I would generally agree with that, Your Honor.
Okay, all right, Ms. Hartman, anything to add?
I would add to, as Mr. Vanderveen pointed out, that they would need to twist. In other words, they would need to amend their amended complaint further to allege anything regarding the fact that the city manager has granted approval on at least one occasion to extend sound past 11 p.m. for the amphitheater in accordance with the current sound ordinance. That is not alleged in the current iteration of their complaint. They make allegations only, as my colleague, Mr. Sweeney, has pointed out, and nothing regarding the time limitations that are imposed by a different section of the city's noise ordinance that does pertain to the amphitheater.
Okay, no, I think I understand kind of procedurally and factually what I need to rule on. Let me bounce back to you, Mr. Vanderveen. Is that notion that, one of the outcomes next Friday that you're going to file, in this case, a third amendment complaint alleging nuisance, perhaps other claims, far-fetched? Am I thinking completely wrong on that?
Well, first of all, in terms of the numbers, there's only one amended complaint. There's the complaint and a First Amendment complaint.
All right.
So it'd be
Well,
a
I'll
second
say,
amended.
been doing commercial litigation long enough. The idea of amending a complaint a bunch of times to get it right is not a bit offensive to me. That happens
Yeah.
all the time. So,
Okay, well, yeah, so you gotta remember that when we filed the complaint and then the amended complaint, no accident had happened. We had projections that sound would be greater than what's allowed under the Planning Commission's conditions and what's allowed under the noise ordinance. And so we filed an action, excuse me, it is a nuisance complaint. Counts 1 and 2 to determine the applicable law of the Planning Commission's ruling and the noise ordinance, and count 3 to declare that the violation of those would be a nuisance per se. Now, those were all done on a prospective basis because at the time you do a declaratory complaint, harm hasn't happened yet. So now we do have the information and the harm that happened. I think the court ruling on the Planning Commission's decision, the Planning Commission's special use approval, and the ruling on the noise ordinance on the motion for summary judgment is crucial. But the problem is if you get into all these other issues, then this discovery is relevant. Then yes, we would ask for the leave to amend the complaint a second time.
okay, well, and I don't want to get too far out ahead of next Friday's argument, on the issue now. And I suspect if I deny the protective order and thus the discovery now is overdue, and you're just we're gonna rehash it to some degree anyways next Friday, because it is going to be relevant at least to a potential amended complaint. It may be relevant to your other arguments in the first place. So what I am going to do, because I think the two are quite a bit tied together here, is I will take this one under advisement. My intention being to rule on it all next Friday as a rolled up package, in that, if we're going to proceed with the nuisance claim, then, and I will say is just a kind of a predictive tool for defense counsel here. Well, clearly, if it's a nuisance claim, it would seem to me that any noise measurements combined with, the requested approvals of going past 11 p.m., that would seem to me to be relevant. It would appear to me that perhaps if we're looking for every single document involving the transfer of the property to the Convention Arena Authority, I don't want to be the person to review all those documents, but it would seem to me maybe we could, some of those may be relevant because they may speak to conditions about the noise level. And in that instance, because the city, arguably would be establishing the parameters, for the CAA's determination of appropriate noise levels. There might be some of those documents, there almost certainly would be some documents there that would be relevant. So just as a, kind of a insight into where I may go with this, assuming this plays out like I am thinking, and we do wind up with an amended nuisance complaint here, I think that realistically, I'm going to have you produce those documents. So putting those together and kind of, getting a handle on the scope of them. So if there's something to talk about there, but, again, it seems like those would be reasonable. I'm not going to issue an order. I'll try to rule from the bench on the whole thing next Friday on it, although I'll be the first to say it sounds like it's going to only get more complicated before it gets easier for me here. But rather than make a ruling today that I need to modify next Friday, I'll roll it all up and at least give my best shot at making a ruling next Friday. So I will take the request under advisement at this time.
All right, thank you, Your Honor.
Thank you, Your Honor.
All right, thank you all.
Thank you.
All right, have a nice weekend, everyone.
Thank you.
Todd Lemon et al. Versus Falcon Custom Homes Incorporated et al. Case number 24-11840-CK. This hearing is being recorded on Zoom and live streamed on YouTube.
And this is scheduled for two matters before the court today. A motion from plaintiff to strike expert witnesses, and then a second motion from plaintiffs for sanctions. So as an initial matter, Counsel, why don't you place your appearances on the record?
Good morning, Your Honor. Herman Hoffman with Barnum on behalf of plaintiffs.
Thank you.
Good morning, Your Honor. Matt Tompkins here for the defendants.
Thank you.
If the court please, Your Honor, Mark Hills also appearing on behalf of defendants.
Very good. Thank you, all gentlemen. All right. Well, Mr. Hoffman, I think these are all your motions. Why don't I take the motion to strike experts first?
Thank you, Your Honor. That motion is about a simple issue. Defendants were given deadlines. They've been given extensions for their expert reports. They've been given second chances. And there was a court-ordered cure procedure that was put into place. And they still failed to provide the expert disclosures and reports that were required by the rules.
Let me pause you, Mr. Hoffman, because I did review my previous order, and I think this was dated, looks like in March of this year, March 6th of 2026. And I do say here, this clearly contemplates this inspection of the house, which I do recall ordering these, but doesn't it stand to reason that that would be the engineering folks that would go, the engineering / building experts who'd go through the house and then make their reports vice. I think you're looking to exclude a couple of, their CPA and also secondarily a rebuttal expert on standard of practice. Why would I exclude those two based on that March 6th order?
Sure. So the March 6th order did concern as well as the inspection as well as the reports. I mean, the Todd Hamstra, that they've identified him as someone who was going to give testimony about construction defects and workmanship issues as well. And so the fact that he didn't show up at the inspection doesn't mean that he was not contemplated by that order. I certainly expected him to be at the inspection, and I expected to receive a report from him. And so I think he was clearly encompassed by the court's order, and the same goes for Boyd Smart. He's with Naderveld, and I don't know, and he was supposed to be he's supposedly retained for workmanship issues and for the construction issues, and so I don't know why he didn't show up at the inspection. But what I do know is we don't have a report from him. We don't have a report from Todd Hamstra. Instead,
and your argument would be the Naderveld, because Naderveld did submit a report of some sort, right?
They did submit a report, and so we are not asking the court to strike or exclude Brent DeRose, who was timely identified by defendants who attended the inspection and who authored the Naderveld report. He's not the subject of our motion, but the experts that are the subject of our motion were either people who defendants did identify, but then did not provide a report as required by the court's order, or they are people who were not identified, but then later, after discovery closed, defendants attempted to inject into this case way after their discovery deadline, and without them having been identified. On the accounting expert, this Tim Reichsa, he was identified previously. Defendants have simply never provided a report from him. They had ample opportunities to do so during discovery. And, I do want to clarify with respect to him, if they want him to testify as a fact witness, as a lay witness, that's, understood. But we don't think he should be able to offer any expert opinions because he has not been given, he has not produced a report. And we did request during discovery defendants to identify their experts and to produce reports, produce their opinions, produce documents relied on by any of their experts, and they didn't provide it. And so They did, on the other hand, provide a report for Michael Kahane, their other accounting expert. And so they apparently know how to do it for some experts, but they decided not to do it for other experts. And just
Well, and let me just pause you on the question of their CPA. I mean, and this occurs, of course, when a doc testifies, as a fact witness, as a treater, but not an expert. Certainly, he can say that his accounting that he performed was within the professional standards. I mean, to some degree, he's opining there on, he's providing some expert testimony, but really what he's doing is defending his work. What you're asking me to do is exclude him from saying, well, for example, the other guy's work was lousy or not within the professional standards, but I mean, he can defend himself, right?
that's correct. Yes.
Okay.
What
All
we
right.
don't, yeah.
I think I understand that. Let me follow up on the other question there, the rebuttal, the hamster standard of care expert. They seem to be saying also here, well, Judge, he's a rebuttal expert. We don't even think we're going to have to call him because you're not going to talk about, you're not going to put on an expert to talk about, at least, what their view is, someone to talk about the standard of care. And I think this specifically drills down to the issues of rebates and or there was another topic in there that he might talk about. What's your thought on hamster may not be necessary?
Well, number one, I don't know how they can possibly say that. They must not have read our experts' construction audit report, namely Jim Schmidt with ResX, who we've retained and who we produced a report for long ago. He does provide opinions regarding the kickbacks, the rebates, whatever we want to call them. He provides lots of auditor opinions. He did a thorough audit of this construction project. And so for them to say that we haven't given any opinions on that, that's simply incorrect. And regardless, just because they say he's going to be a rebuttal expert, that doesn't mean that he can be a secret expert. They still have to disclose his opinions, facts, and grounds. I have no clue what he's possibly going to say, and they were required to disclose that under the scheduling order and under the based on the discovery requests. And so whether it's a sanction as a failure to comply with the court's scheduling order or a sanction for failure to comply with and to supplement their responses to our discovery requests, either way, he should be excluded because we have provided opinions. And so if they're just going to say, that they don't think he's going to rebut anything that's said in Mr. Schmidt's report, then they shouldn't be able to do that because they have not provided any rebuttal report.
Okay. All right. No, I think I understand the arguments here for the exclusion. Let me give the defendants an opportunity to argue. Who's gonna handle it?
I'll take a stab, Your Honor. Good morning. Just to update the court, Monday and Tuesday of this week, we spent well over 12 hours in discovery depositions of the three engineers from Netterville. Mr. Hoffman's colleague, Mr. Selvius, deposed Lucas Potchel for about 5.5 hours Monday. Tuesday, Mr. Chris John was deposed for over 2 hours. Mr. Brent Rose was deposed for over 5 hours. So those folks had been deposed, vetted every one of their opinions. There is no basis to argue any sort of undue surprise or trial by ambush. Back in, I believe it was early September last year, we disclosed Mr. DeRose and Mr. Boyd Smart of the Netterville firm we had to litigate the issue on inspecting the home, and there was a delay inherent in that litigation process, which did not allow Netterville to get up to the home until May of this year. At
It
that
sounds
point,
like Boyd Smart never made it to look at the house, right?
that's correct, Your Honor. And Mr. Potchell and Mr. DeRose and Mr. John, for that matter, all explained what sort of transpired. By the time the inspection came about, just by personnel considerations alone, Mr. Smart was not available. Mr. John stepped in his place. So it was Mr. DeRose and Mr. John at the inspection for multiple hours with Mr. Hoffman and both of his clients in attendance, as well as with the representatives from Falcon. Mr. John and Mr. DeRose co-authored the report that was timely produced pursuant to the court's March order that Your Honor referenced a moment ago. Mr. Potchell explained, as did Mr. DeRose, that Netterville's internal best practices is to have another engineer review the work. That's what Mr. Potchell did in terms of Mr. DeRose's scope. Mr. Potchell did not attend the inspection, but has done a complete thorough analysis, and again, was deposed for over 5 hours. So
Sounds like we're not going to hear from Boyd Smart, though.
That's correct, Your Honor. That's correct.
Okay. Insofar that we're kind of parsing the witness list, we got 3 that did testify, but Smart is out. He didn't do the inspection and didn't do the review either, so he would be off the list. And you would say the 3 that were deposed would be the ones that would proceed to trial.
That's correct, Your Honor.
All right. What about what's your plan for the CPA? Are you asking to qualify him and have him talk about GAAP and, accounting practices in general? Is he just going to get up there and say, here's what I did, and it was, it was compliant with standards, but I'm not trying to opine. What's the thinking on that?
Thank you, Your Honor. I appreciate that. So Mr. Rixey is the longtime accountant for Falcon. And he obviously is a CPA, and any testimony that he would provide would be sort of through that lens. We don't contemplate having Mr. Rixey provide countervailing opinions to Mr. Schmidt, who is the plaintiff's economic damage expert. But the court may recall that throughout the course of discovery, multiple instances required Mr. Rixey and his staff to put together reports that never existed in the first instance. And so he certainly will be needed to lay that foundation, and in so doing, will do so as an accountant. So that's our position with Mr. Rixey, is that he clearly is more than a fact witness in the sense that he actually did work up in the case per the request of the plaintiffs. And so that's the rationale for Mr. Rixey. Mr. Hamstra is a rebuttal expert that we did retain specifically to address the standard of practice or standard of care for this, what the plaintiffs have sort of colloquially termed this kickback scheme. We have not seen any kind of an expert report on that from the plaintiffs. They have not disclosed any expert that's an industry insider that can speak to that. Mr. Schmidt
is going to rely on Schmidt's report, and you're saying Schmidt's more of an accounting person.
Schmidt is solely an accounting person, Your Honor. And that's why we retain Mr. Cahayan and his group to counter Mr. Schmidt's opinions. So we don't have anything for Mr. Hamstra to respond to at this point. And that's why we have characterized him as a rebuttal expert, but who may not be necessary to testify in our view of the world, because the plaintiffs haven't offered standard of care expert testimony. So those are our positions, Your Honor. I'm happy to answer the questions, but that's kind of where we stand.
You don't want me to strike Hamstra today because, of course, you don't know what the testimony is going to come out with at trial, but you'd like to keep him at least potentially available as a rebuttal witness, even though as things sit today, you don't, from your perspective, he doesn't have anything to rebut.
That's exactly right, Your Honor.
Okay. All right. Well, on the motion to strike, have reviewed the briefing and also heard the arguments today in court. In the order of the court, my view is reviewing my previous order, that is the one issued in March of this year, that did contemplate this inspection of the home. And I do recall, of course, you know, as would be expected, the house is in Petoskey. The experts are coming with lawyers in tow, at least for some of the parties, you know, from points afar. It was quite a project to coordinate a day that would work for everyone for inspection of the house. And at the end of the day, it appears that two engineers, that is Mr. John and Mr. DeRose from Netterveld, did perform an inspection of the house and created a report. And those two then certainly would be allowed to testify, as well as Mr. Patchell, who performed a professional internal function at Netterveld when he reviewed the report. Boyd Smart, who was initially contemplated as a Netterveld expert, was not able to make the inspection and has been acknowledged today it won't testify on behalf of plaintiffs. So it may be granted in part as to Boyd Smart, denied as to any of the other Netterveld, well, the three Netterveld experts listed today who participated in the actual inspection and the review of the inspection document. With regard to Mr. Rixey, the CPA for Falcon, I will, obviously, he's been listed and contemplated by the court going forward as a fact witness. He was the CPA. Very hard for I've attempted to do this myself, never with good results. Back when I was a litigator, where you say, well, my guy who works for me is also going to be my expert. There's a little bit too much built-in impeachment there for the other side, in my experience. However, Mr. Rixey is a CPA, and it would be, of course, expected that he would defend at least his own work, saying I complied with, you know, the generally accepted accounting principles that I'm held to as a CPA. Some of that does bleed into what might be referred to as expert opinion testimony. However, in the end of the day, he's testifying regarding his work on this specific case, which I will note did include the production of some reports or formatting of some reports that he'll need to explain why he did so in response to this litigation. So Mr. Rixey will be retained as a fact witness. I will reserve ruling on whether or not he can provide expert testimony until the time of trial. And as I said, I would expect, of course, he's able to testify to defend his own work. Whether or not broader expert testimony is needed from Mr. Rixey, I think would most be appropriate after I hear his fact testimony at trial. I'll note he wasn't listed as an expert witness, and I certainly wouldn't expect him to, you know, be used broadly as an expert witness. However, my experience with these cases is there's a lot of overlap between fact testimony and expert testimony, and I may allow at least some limited expert testimony at the time of trial. So I'm going to reserve ruling on his admission as an expert. With regard to Hamstra, it appears at this point that you know, both sides are in disagreement as to whether or not you know, what Hamstra was propounded for, that is industry practice. And again, that could be an accounting question, that could be a construction expert type question. However, it does not appear at this point that plaintiff is going to bring in, you know, necessarily you know, the direct type of expert, a hamster type expert who would need to be rebutted. However, I will allow him to remain on the list as a rebuttal witness. I will also allow a reasonable amount of time for his deposition. If I think we got an October trial date here.
October 19 is when it's scheduled to start.
All right, so deposition to be dates to be provided and noticed within the next 30 days if plaintiff wishes to depose Hamstra.
And Your Honor, one clarification, could we have the same as to Reixa? Again, we were expecting a report from him, and that's why we didn't seek his deposition. But now that they've clarified that, or at least and the court has clarified that.
Yeah, he may virgin, you know, well, and you don't know what you don't know. I would, yes, let's have a deposition of Reixa at least agreed to by the parties and noticed up within 30 days.
Thank you, Your Honor.
All right, and Mr. Ross, I noticed you on this. I don't think you're on this case. Or no, you are on this case.
Hi, good morning, Your Honor. I am counsel for Frankenmuth in the related deck action, so I'm just
Okay.
seeing what's
Mainly
going
here
on
as an observer. I didn't want to let you, leave you out if you had things to weigh in on. So, but I don't think that probably those decisions that I just made bear in any respect on the deck action. So, unless you raise your hand, I'm going to just let the lawyers on the primary action here proceed. So,
Yes.
all right. Next
Your Honor.
one up before the court is the sanctions motion. I have to confess here, Hope got me the information on the motion to strike. However, the sanctions motion, I'm a little unclear on, and I view it as probably somehow tied up in the idea that I ordered payment of that escrowed fund, and then the Court of Appeals said, Judge, you put the cart before the proverbial horse on that and shouldn't have done it. And obviously, my intention here is to follow the order of the Court of Appeals, though I don't think I've entered necessarily an order vacating my previous award yet. What's the status? Why don't you lead off for me on that, Mr. Hoffman? What are you asking for?
Thank you, Your Honor. And on that motion, yeah, we did just want that clarity from the court. The way I read the Court of Appeals ruling is that it vacated only the deadlines, the April 26 and July 23 deadlines. And so we were just asking the court to confirm that the merits ruling remains intact, and we would then also request the court to simply defer ruling on this motion until after, at the time of or after a final judgment is entered. And so that's what we were requesting. That's what we are requesting the court to confirm at this time. Again, the merits ruling remains intact, and that the other issues in terms of costs and fees would be adjudicated after a final judgment is entered, at or after a final judgment is entered, as the Court of Appeals noted.
All right. Well, and I do have to admit I don't have that Court of Appeals opinion in front of me, because every time the Court of Appeals overturns me or challenges my judgment anyway, I immediately crumple that up and throw it in my circular file in a fit of anger. But nonetheless, my recollection of my reading of it was that, well, at least they said, Judge, you can't do that now. You got ahead of yourself a bit. Who's going to respond for defendants on the sanctions issue? Mr. Hills? I think you were the winner on that one, Mr. Hills. You have to unmute those.
Sorry, Your Honor. Yes, I think I drew the short straw, as it were, on this one. Your Honor, my concern is this. Well, we may have made clear in our filings before this court that we do not challenge the substantive determination of the court as to that construction deposit. Simply saying that the deadlines are the only thing vacated by the court, we do not believe to be accurate. And to the extent that there is a suggestion by counsel that later they are going to seek some imposition of sanctions for failure to pay that at any point in time before a final judgment is due, is one, incorrect legally, two, in violation of the Court of Appeals clear order. So if it's simply a function of, let's confirm that the determination that the construction deposit is due at some point, I think that's probably okay. Oddly, it's not in the context of the motion that was renoticed for hearing today. That motion is temporally defective and as presented legally defective. So simply noticing it up and saying, well, Judge, we just want you to do actually something than what we asked you, I think is inappropriate as well. So I think it's more than simply we need to vacate those two deadlines, because that suggests something more than we believe what the Court of Appeals said.
Okay, well, what I can do at this moment is, Mr. Hoffman's acknowledged that, right, much of this is and I certainly think the Court of Appeals, part and parcel of what they did say also was, Judge, whatever you're going to do, you can't do it right now. You got to wait until entry of final judgment in the matter. So what I will do is I will deny this without prejudice at this time and readdress it if re-urged by the plaintiff at the time of any final judgment, should one so issue in this case. So that'll just be denied without prejudice at this time.
Thank you,
Very good,
Your
Your
Honor.
Honor.
Thank you, Your Honor.
Anything else we need to address, gentlemen, as this thing clunks towards trial? I expect we'll probably get a flurry of pretrial motions and things. I would say with regard to those motions in limine, sooner you can get them in front of me, the sooner I'll decide them and give you clarity on how much time did I set aside to try this one, Lisa?
It's 2 weeks, I believe, Your Honor.
2 weeks, Your
That
Honor.
sounds accurate to me. We still good
Well,
on that time estimate?
Well, Your
Yes,
Honor, in
Your
that
Honor.
regard, I think it would be helpful if we had some sort of a Zoom or telephonic status conference sooner as opposed to later, because there are a number of logistical issues that I think it would be good if we started to talk about now.
I wholeheartedly agree, because now's the time when experts are buying airline tickets and stuff like that. Why don't you send me some available dates to Lisa? She'll take a look at my calendar. Let's try to get just we don't have to be on the record. We can just get a status conference on the prep for trial. And then, sometimes on these more complicated cases, I've issued I'm going to call a pretrial, scheduling order that has some deadlines to get those pretrial filings in, just so we're all on the same sheet of music.
I think
Thank
that
you,
would
Your
be
Honor.
helpful, Your Honor.
Very good. Dates to Lisa. Lisa will have a final say, and I think we can probably accomplish that within 30 minutes.
I would assume, Judge, yes.
Very good.
We do have quite a bit of time available the week of August 24, if that works for anybody.
That works for me.
August 24th specifically is pretty wide open for my calendar.
Mine as well.
Okay, on the Monday, the 24th,
Yes.
does
Yes.
it work for you, Mr. Hoffman?
Yes, Monday the 24th works for me as well.
Okay, shall we do it at
Mr. Hills,
11
is that
o'clock
going to
on
do it on
Zoom?
for you too? We gotta.
Yes, I said so. Yeah, I'm wide
Oh,
open.
good.
that
I'm
day.
sorry, I didn't hear it.
11 o'clock on Zoom on Monday, August 24?
Perfect. Thank you very
Very
much.
good. Will the court send notice, or would you like one of us to send notice, Your Honor?
How do we do it, Lisa?
I can send notice.
Very good. Thank you, Lisa.
You're welcome.
Thank you, Your Honor.
Your Honor, one clarification. Would you like me to prepare a proposed order and submit under the 7-day rule on the 2 motions?
Yes, that'd be great.
Okay, I'll plan to do that.
Thank you all.
Have a great weekend, everybody.
Take care.
Van Zijtveld versus Provision Living LLC et al., case number 26-20412-NH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter is before the court today on a motion for entry of a protective order allowing ex parte meetings and interviews between defense counsel and the plaintiffs treating healthcare providers. I would invite counsel to place your appearances on the record.
Michaeline Sawinski on behalf of the plaintiff. Good morning, Your Honor.
Thank you.
Good morning, Your Honor. Michael Palucci on behalf of the moving defendants, Provision Living LLC and PVL at Grand Rapids LLC. Your Honor, I would also just let you know, I got an email from the co-defense attorney who represents Senior Village Management LLC yesterday. They concur with the defendant's relief and indicated that they would not be appearing this morning.
Okay, very good. Thank you. Then I'll include them in any order that ultimately does issue here. Ms. Saminsky, did you file a response brief? Are you opposed to the protective order as proposed?
I believe we did file a response brief, Your Honor, and yes, we are opposed to it.
Okay, and unfortunately, that response brief did not reach me in time because I didn't review it last night. Why don't you summarize your arguments for me?
Yes, Your Honor, we do oppose it. We don't believe that there is good cause for the protective order to have the defendant talk to any and all medical treaters of the plaintiff's decedent. The plaintiff asked if the court does allow that type of protective order, that the court put conditions on it, such as providing the names of the medical providers and to provide notice that the defendant has reached out and spoken to the medical providers. If I were to reach out to a medical provider, even though I represent the plaintiff, I still have to provide notice to my client and be provided with an authorization and provide an authorization to a medical provider before that medical provider will speak with me regarding protected health information of the plaintiff's decedent. We would request that the defendant just provide us notice that he has spoken to the medical providers of plaintiff.
Okay, all right. Well, let me hear Mr. Pialucci. I will note that of course it's quite well established under Michigan law that these ex parte interviews, meetings with healthcare providers are generally permitted. What about on the issue of notice, Mr. Pialucci?
All right. Well, first of all, number one, I believe that our attached proposed qualified protective order marked as Exhibit A to our motion complies with HIPAA requirements and complies with Michigan case law. The two provisions that they want to add to the QPO, I don't believe are supported by Michigan law. They want us to identify the specific providers that defense counsel would request to either meet or interview with. That is objectionable on the attorney work product doctrine as to which physicians or healthcare providers we would like to meet with. That goes into mental impressions of the witnesses or treaters that we believe are relevant to meet with based on the claims made. And interestingly, when an interrogatory is sent to the plaintiff asking for treaters that they've met with, they invoke the privilege, attorney-client privilege, work product privilege. So apparently they think that it's okay for us to give work product out, but they don't have to. In terms of the notice provision, they want 7 days advance notice of any treaters or healthcare providers that we meet with. That has been clearly established to be not required under the Michigan law. We've cited in our brief numerous cases, Holman, Spock, DeLuca, D'Amaco. The law is very clear, Your Honor. The Court of Appeals and our appellate courts have ruled on both notice before the meeting and after, and it's just simply not required. I don't believe there's any good cause that's been established by plaintiff for the two conditions that they've requested, namely identification of the treaters and advance notice. And for the reasons set forth in the brief, the case law that we've cited, I would respectfully request that the court enter our proposed QPO attached as Exhibit A to our motion that I believe complies with Holman and Michigan law and HIPAA. Thank you, Your Honor.
All right, well, thank you. And I have reviewed the motion. As I said, unfortunately, I think the response probably just simply came in too late to get in front of me here, but I did hear the responsive arguments. And the responsive arguments, as I said, these ex parte interviews are quite well established under Michigan law that they're permissible for defense counsel to conduct, pursuant to appropriate HIPAA and case-specific limitations on those interviews, to prevent any impermissible use of healthcare information that would be provided, and of course to protect the providers as they're speaking to defense counsel. Plaintiff in this instance also requests some additional notice, that is notice prior to and then after such ex parte interviews have occurred. However, The Court of Appeals, specifically in the SPAC opinion, which is SPAC versus In Yang 290 Mishap 711 2010, did say that any additional conditions, specifically regarding notice, is not permissible and can't be added without good cause. And I simply don't see any good cause to add those notice provisions, and further do share defendant's concern about that disclosing the timing, length of the interview, sequence of interviews, etc., could intrude on attorney work product privilege, and that is how they prepare their case. So I will sign the proposed qualified protective order without any notice provisions at this time.
Thank you, Your Honor.
Thank you, Your
Thank you.
Honor. Have a nice day.
You
Have
as
a good
well.
day. Thank
All
you.
right, bye-bye.